You're being questioned at your pretrial deposition, and the defense attorney asks you a question to which you think has no relevance or bearing on your particular case. Do you have a right to turn around and say, "I'm sorry, that's a ridiculous question. It's not related to the issues in this case. I'm not answering it"? Would you like to learn the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, you do have to answer that question, unless your attorney has said, "Objection! I direct my client not to answer that question." Now, what you are talking about is what we call, lawyers call, a relevance objection. Now, what does that mean? During the course of your lawsuit, the defense attorneys, the attorneys who represent the people whom you have sued, will have an opportunity to go ahead and question you in a pretrial question and answer session known as a deposition. This deposition is also known as an examination before trial. And in pre-COVID times, this would typically take place in our office, in our conference room. During COVID times, it takes place on a Zoom video call. And the defense attorneys are on the call, you are on the call, obviously, your attorney is on the call, and a court stenographer is on the call. Why? To record all of the questions that you are asked and all of the answers that you provide. The answers that you give represent your sworn testimony, and it carries the same exact weight as if you are testifying at the time of trial in front of a judge, in front of a jury. So the answers that you give actually are significant and they are very important. So now, the defense attorney asks you a question and you're thinking, wait a second, what the heck does that question have to do with the issues involved in your particular case? You claim that your doctor was careless and that his carelessness was a cause of your injuries and that your injuries are significant and permanent. This defense attorney is asking you questions about your family medical history, about your background, about your spouse's medical history, about your parents' and your grandparents' medical history. And you're saying, what the heck does that have to do with anything about the facts of your particular case? The reality is that it might have something to do with it. Why? Your history, your spouse's history, your family's medical history may be significant for the purposes of evaluating you and treating you and trying to understand what was going on with you at the time that you presented to these various doctors and hospitals. So now, what happens then? What happens then is that the defense attorney is going to persist in asking you these questions. It's not sufficient for you to simply say, "That's not relevant, I'm not answering the question." If a question is asked and it is not relevant or related to the issues in your case, your attorney will go ahead and speak up and alert the attorneys to the fact that it is not relevant. The only person who can really object to a particular question is your attorney. Your attorney will yell out, "Objection!" And then he has to make a decision. Is he going to allow you to go ahead and answer that question? Or is he going to turn around and say, "Objection, I direct my client not to answer the question"? And now there's going to be a legal battle, a legal discussion, a legal argument amongst the attorneys about whether or not you actually have to go ahead and answer the question. Let me clue you into a little secret here. In these civil cases, these civil lawsuits involving medical malpractice, involving accidents, involving wrongful death, in almost every single instance where the attorney, the opposing lawyer, asks you a question to which you think is not relevant, in almost every case you are going to have to answer that question. Now, why is that? It's because this is known as the discovery process. The defense is given great leeway to ask questions that truly may not be related and relevant to the issues in your particular case. However, because this is discovery and because this is the only way for the attorneys to learn information that's not contained within your medical records or by talking to their own clients, the courts allow the lawyers, these opposing lawyers, to ask questions even though they may not be relevant and even though they may not be able to use that information at the time of trial, of course, if your case goes all the way to trial. It's an opportunity for them to learn. That's called the discovery process. So that's why the courts are very liberal in allowing the witnesses to go ahead and answer questions, even though you may feel it's not related, even though your attorney may feel that question and that answer is not related. However, that is not for you as the injured victim bringing a lawsuit to decide. So just because you feel that a question is not relevant, you can't turn around and say, "I'm not answering that question." And by the way, if you did, after your attorney tells you to go ahead and answer it, you know what would happen? After your question and answer session is finished, the defense attorneys would then go to the judge who's handling your case and say, "Judge, this witness has stopped us, has prevented us from learning critical information about what's going on here." And you and your attorney would argue that it's not critical, it's unrelated. And you know what? In all likelihood, the judge is going to say, "I'm going to direct that this witness reappear for questioning," and the defense attorneys will have the opportunity to go ahead and ask those questions. Ultimately, a trial judge will decide whether or not those questions and those answers are relevant and related to the issues in this case. So why do I share this quick information with you? I share it with you because this comes up in many depositions, many pretrial question and answer sessions, where the injured client, the injured victim, turns around and says, "What does that have to do with my case? What does that have to do with the allegations I made against the doctor and the hospital staff?" And the reality is, it might have nothing to do with it. However, the defense is entitled to ask the question most times, and they're entitled to get an answer. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.